and the respondent government has relied upon cases from the Armenian judiciary relating to supposed cases of Azeris being able to have their rights redressed and to obtain effective remedies from the Armenian courts. Those cases have tended to be slightly misstated. They've not related in all cases to Azeris or to Kurds. One of those three that they've referred to in the past, in their 2007 submissions, actually related to an Iranian man, and none of them at all related to an IDP. These were cases related to very minor, uncontested matters, contract disputes, real estate disputes, employment disputes. There is certainly nothing at all of the kind of sensitive and conscientious, difficult situation in which this court is faced today in dealing with an ongoing armed conflict. I'll turn now to my colleague, Mr. Ivers.
And before I just let Mr. Ivers deal with one of the questions concerning Article 1, Protocol 1, let me just say one thing about the human rights defender's position. My learned friend suggested that somehow the human rights defender was barred from taking up the case of our applicants and that somehow it required an application on behalf of the applicants to be registered in Armenia. I just point to paragraph 48 of his own submissions, in which he says the defender has locker standi to challenge executive action and legislation, even by the President, on grounds of inconsistency, and that he may therefore directly approach the Constitutional Court for a remedy. An important feature of the power of the defender to accept individual complaints is that it's not confined to complaints of citizens, but rather to any entity, regardless of nationality. So it follows from that it was always open. We do not, for one moment, just as my learned friend for the Azerbaijan government has submitted, do not for one moment accept that the human rights defender was capable of providing remedies, particularly in relation to Article 8, or in fact the right to return to one's home. But what we do say, however, is that the submission that somehow they were champing at the bit in order to take up this case is manifestly fanciful. And just lastly, you can examine that within the context of your own judgment of 2011 in December, where in actual fact you had to entertain the submission relied upon by the Armenian government, firstly that the NKR legislature had extinguished the property rights of our client, and secondly that this was not in actual fact the appropriate forum in any event, that it lay within the Minsk process. Both those were rejected. It was only within that context that this new submission concerning free and unfettered access to Armenia arose. And we submit it as highly dissembling and artificial, given to the fact that actually for 7 years no remedies were identified, and indeed no representation was made inviting the applicants to return to file claims. Lastly, in relation to the question concerning whether or not Article 35 has any relevance if it related to an independent state that had not signed the European Convention on Human Rights, we would submit it would not be relevant.
Thank you. I'm afraid your time has expired, so I think we have to conclude. I mean, you have to conclude.
I can deal very quickly with the Article 1, Protocol 1 point, and we can have a couple of just observations in relation to jurisdiction thereafter.
I give you 2 more minutes, but that's it. Yes.
In relation to the Article 1, Protocol 1 point, can I make clear that our principal case is that there's been an administrative practice that denies the return of these IDPs, and that goes not just to the merits, but also to the question of exhaustion. As regards any positive obligations, although there are no positive obligations one might discern under Article 1, Protocol 1, of course concurrently the loss of a home affects Article 8, and there are positive obligations in relation to Article 8. And just finishing, we rely also, of course, on the Court's judgment already, paragraph 104, which stated that while the applicant's displacement in 1992 is to be considered as resulting from an instantaneous act falling outside the Court's competence, their ensuing lack of access to the alleged property and homes is to be considered as a continuing violation. So the continuing nature, if the facts were made out, would be established, and that's what we'd say.
Mr. President, exceptionally, could I ask for just 3 more minutes? We did receive a number of detailed questions from a number of judges, and in these circumstances, and particularly to avoid perhaps the need for further written clarification, I would indulge this court and ask for permission for just 3 minutes from a learned
Yes, I exceptionally grant you 3 more minutes, but I will grant 15 minutes to the respondent government. Please, you have the floor.
In response to Judge Spanio's question about the best evidence on military presence, I refer to the first 6 points that I listed in my oral presentation. I preface that by saying one should observe that whereas in Wazidu it was 30,000 Turkish soldiers that made the difference, in Ilashku it was only 1,500 Russian soldiers, which was sufficient to create effective overall control in the territory. As to those 6 points that I highlighted, I make the following further observations. There was the statement by the respondents present about returning the security zones, completely unrebutted. No suggestion he was misquoted. That may well be the short answer to the whole jurisdiction point. Forget their generals, their own president has given you the answer. I highlight the third point, the evidence from the International Institute of Strategic Studies. I also refer to their military balance publication, which states in terms the respondents' troops make up a large contingency of the standing army in Karabakh. The fourth and fifth points I also highlight, the Charles Blandy analysis, which gives us numbers. He estimates overall strength about 18,000, of which only 8,500 come from Nagorno-Karabakh, some 10,000 come from Armenia. There we have figures. Those broad figures are corroborated by my fifth point, the International Crisis Group report. Quote, over half of Armenia's army are believed to be Armenian citizens. The respondent attempted to discredit this by producing a statement from Mr. Richard Gagosian, one of the sources. I really urge the court to read that statement. As I said earlier, he doesn't actually withdraw his opinion. He maintains his opinion as to what he stated. One also needs to stand back and ask what evidence there is against that. Not one single contemporary document. They admit conscripts. They don't give us documents on this, even though they have them. Instead, they rely on this so-called expert, Dr. Harib Bukur, remarkable document based on undocumented interviews. It is worse than hearsay, because it doesn't actually tell us what the interviews said. And ultimately, you have these generals, but one Sargsyan says he doesn't know the position, another Balian maintains massive defence procurement are official secrets. Ultimately, the court has to prefer the independent, objective evidence that has been given, as I've outlined, which does its best to give numbers in circumstances where, as we have said, the respondent has a policy of dissembling and of trying to keep matters secret. I'd also like to address Judge Ziemel's question on the legal position. Primarily, we are saying that all these international law authorities are not relevant because we are construing the concept of jurisdiction in Article 1. Alternatively, as we understand the point being made, it's really the respondent's point. They are saying that Nicaragua and the genocide case, the ICJ laid down a detailed control test. In Nicaragua, in relation to the actions of the Contras, in the genocide case, in relation to the actions of the Bosnian Serbs. Superficially, that would appear to be different to what the court has said in terms repeatedly in the cases I cited, Al-Skani, Wazidu, Ilashku, where it says you don't have to show detailed control. But it is a superficial difference. It is not a real difference, we say, because in those cases, the court was developing its own concept of jurisdiction, and it was a territorial concept. If you look at the wording, everything it says is in the concept of, say, talking about effective control over an area. And it's in that context it says you don't have to show detailed control over local administration. That point simply did not arise in Nicaragua or the genocide case. They were talking about actions of specific individuals and groups. It was much closer to the court state authority line of jurisprudence. So there's no real difference. That's the answer.
Thank you. I give the floor now to Mr. Robertson. Mr. Robertson, please.
Thank you, Mr. President. If I may answer firstly, I think there were 10 questions to which I will have to answer, so I'm going to be rather quick and to try to identify those parts of our pleading, particularly our evidence and argument, which seems to answer the question. The first question is whether Nagorno-Karabakh, not having signed the convention, applies it, given that Armenia and Azerbaijan has. This is the legal black hole that is suggested by Azerbaijan. Is Nagorno-Karabakh a legal black hole? By no means. Not only does it have 18, I think 24 judges in full in a Supreme Court, but a bar association of over 50 lawyers. And we have a convention that is applied. The Chief Justice of Nagorno-Karabakh says so in terms when he was asked whether it was applied. He said that the courts of Nagorno-Karabakh apply the European Convention. You'll find his statement, which sets out and refers to a number of cases, at Appendix 8 to our 2012 submissions. And indeed, we include a case, Appendix 32 to our 2012 submissions, where the convention is applied. So there is, and the judge from Lachin, who was also gave a witness statement, said in terms that he applied the European Convention. I think that's Appendix 9 to our 2012 submissions. So there you have the convention, European Convention, applied by the Supreme Court. You have evidence from the Chief Justice that it is applied. You have cases. He refers to a number of cases where it's applied under Article 6 and so forth. And you have the Chief Judge of the Lachin area saying in terms that he applies it. So the second question, which was is in terms of the ICJ approach and its connection with the current law applied by this court. You will find our submissions on this matter at paragraphs 112 onwards, where we compare and contrast the ICJ approach in Nicaragua and other cases to the European approach, a European court approach in the Turkey cases. We don't rely, as I said in my opening, we don't nail our colours to the ICJ mast, but we put the material before you. And if you look at Judge Bonello's concurring opinion in Cyprus and Turkey, you'll see that he draws very strongly on the ICJ and says there's a dilemma here that the court has to solve. It has a real problem in this area. So we deal with the cases at 112 onwards, including Al-Skani. So, in a sense, we recommend that the court square the circle and adopt the ICJ approach, which does, in some respects, is clearer, particularly in relation to showing effective control over the court system. It's not just a matter of showing boots on the ground, and of course, for all the spy cameras and satellites that the Azeri army has no doubt